Welcome back to the Legal Weekly Wine. What a week it has been. Last 2 weeks it has been with Supreme Court decisions. So it is mid-June. Goodness, it is June 23rd is where we are. And we are looking at several different decisions. We're going to do some recaps of the 2 Native American cases as well as the Alabama redistricting case. So that is what we're going to talk about today because those are the hottest legal topics that have just come out. And then we're going to see what happens next week. I understand we have quite a few decisions coming out next week too. Is that right, Dr. Weil?
It is. Looks like we should have a good affirmative action case or two. Almost always there's either a establishment clause or a free exercise clause case, religion case, and there may be another surprise or two waiting out there. Again, I was disappointed today. I mean, I looked at the 4 cases and I thought, oh my, and
from Thursday,
all of them are consequential to the parties, but and one particularly, which I don't think you plan to mention.
I'll throw it in there. Let's talk about it.
Well, I mean, as a former criminal attorney, this Jones versus Hendrix has to do with collateral habeas corpus review, which is something that only your most sophisticated listeners are likely to know anything about. But habeas corpus review is basically a way to move a case from a state court to a federal court. And in this case, and particularly during the Warren Court, there was very wide review. The court stepped in 4th, 5th Amendment cases, a lot of them. And then starting with, I would say, probably the Rehnquist court, the court began saying, we've settled many of these issues. It's in the state courts. We can pretty much trust them. And this decision seems very much along that same line. It's the facts are fairly complicated, but essentially someone's had a conviction confirmed. There is a congressional statute that does still permit what's known as collateral habeas corpus review in a limited number of cases, but the court found that this didn't really fit either of those, and therefore, if any changes were to be made, they would have to be made at the state level.
Goodness, yeah, that definitely is technical.
It is, but it's one of the things that I think we're seeing is a little bit greater deference on the part of the court to congressional laws and statutes that are in effect. Yeah. And they gave, this habeas corpus case has more to do actually with what we call statutory interpretation, which is what do the laws mean, than what, constitutional interpretation, which is, going back to the very basics. So I think it's in line with other decisions, and at least one, maybe both of the cases that deal with the Navajos are in a similar situation.
I agree. Okay, so I'm going to stop you there because in anticipation, we are talking about the week's hottest legal topics, but we are also talking about wine. And I am so sorry I can't share any of it with you. But we have the water that may turn into wine, right?
Exactly. Just the right person shows up, we'll be fine.
So we'll be anxiously waiting for Jesus to turn the water into wine. And in the meantime, I will drink the wine that is already wine. We have a little shop in our town. So in Gaithersburg, Maryland, there's a little shop. I want to get it right. It is finewine.com. It's in what we call the Rio area. And it's this beautiful little wine shop. And they are experts in what they do. I am not, but they recommended this wine to me. I'm going to try not to butcher the things that it says in the way that it is, but it's Bigaro. And it is, I'm not going to pronounce it. So I'm going to hold it up closer. I will put it on the video so that you can see, but it's a beautiful rosé. I will put more information. You can see the color is really nice. I'm not sure much about it, but I'm going to drink it. So cheers to the weekly wine. Oh, that's very sweet. I like sweet wines, and that is very sweet. It's almost like drinking a dessert. Almost like a sorbet or a sherbet or something. You might actually like it. Yeah, it's not, but it feels almost like it. I think you would actually like it. It almost is like a raspberry, as if I'm going to an ice cream store and getting a sorbet. Okay, I'm good with your recommendation. I like it. I'll put the bottle in the comments as well as the information on it. And let me introduce you. I'm Virginia Tehrani. Most people are used to hearing me by now. I'm the owner of Tehrani Law LLC, because you never need a lawyer till you do, operating in Maryland, D.C., and Virginia. And I'm the CEO, my sister's the COO, the CEO of the Law Unscripted, which is hosting this podcast of the Legal Weekly Wine. And it is Supreme Court season, which is why we have Dr. John Vial with us. He is a preeminent legal scholar, constitutional law scholar, knowing everything you can possibly think of about the Constitution, the amending process, constitutional law, the Supreme Court, the Constitutional Convention, and I could name so many more. But you are truly the expert on the court. You are on top of these decisions, which is why I'm so grateful and glad that you are here with us today.
Glad to be here.
All right, so we're already discussing this complicated Habeas Corpus Act, but I think what I want to pick up on is the idea that the court is making judgments, making decisions that are aligning themselves, especially with deference to other statutes and congressional issues.
And, you wonder in a sense if this is in part a reaction. In Dobbs, the abortion decision, they overturned basically 50 years of precedent. Now,
which was last year.
Right. That precedent in turn had overturned prior cases.
Right.
But with that exception, so far, they seem to be hewing fairly closely. And I guess one of my concerns is, and I'm sure not everybody will share this thought, but in terms of democracy, deference to the most representative branch, which is usually considered to be the legislature, seems warranted. On the other hand, it's hard to think of a time, in my judgment, where the Congress has been more dysfunctional than it is right now. And, this is particularly true with regard. Now, it's not the first. There have been many times in history where Congress has tried to clip judicial jurisdiction or adopt amendments to overturn court decisions. But both sides, one probably more than the other, but one side is accusing the other of weaponizing the Justice Department, and I think the side that's doing the accusing has probably provoked more of it. I think the Trump administration, and again, not everybody would share this view, but
of course,
I think much as any, they really did, weaponize the Justice Department. They had a very, in my judgment, partisan attorney general who stuck pretty close to the president. Now, they would say, well, the Democrats twice impeached Trump and he did nothing wrong. If you think he did nothing wrong, right. If you think he did nothing wrong, then yes, that was weaponized. But if you think if you think he did something wrong and the only reason he wasn't convicted and removed was that his party stuck by him, then you have another situation. And of course, just yesterday you had the House voting to censor someone who I think led a very credible investigation into the Trump administration. Now, the impeachment was not successful, but this would be like impeaching, trying to fire a lawyer because they lost a case, particularly if the other side had been able to choose a jury.
Sure.
There are a lot of cases, but having then voted to censor one of these investigators. What do? Well, a lot of them now want to impeach Joe Biden. Well, give me show me a bribery, show me a treason, show me a high crime or misdemeanor. and then I'm willing to listen to you. But it sounds like impeachment, maybe on both sides, but I think particularly on one, has become, it's just something, it becomes a show.
Right.
Performance. And it's one reason I used to think that I wanted to go into politics. And I've since decided that if I did, I would have to run for emperor or something, because the notion of being in a legislature and watching all of this nonsense, I think, would probably drive me nuts.
Yeah. So we do have the cases that we're looking at with the Native Americans. They seem to be, like you said, very deferential to what Congress has already enacted, treaties with the Native American tribes, laws about the Native American tribes. And I guess I want to ask you, in looking at the separation of powers, where we have the original 3 articles, right, for the legislature, the president, and the judicial, where are these laws coming from with regard to that separation of power?
Well, I mean, if we're dealing with laws, they're going to fall primarily under Article 1, Congress's power to adopt laws. Now, what is interesting is the case today, the second case involving water rights, the court finally sort of got it right. They say Congress and the president have adopted, I guess this one was actually a treaty rather than a law.
That's where we're getting is what is the treaty involving with the articles versus just a law?
Right. Now, I believe the treaty it's divided. The president basically negotiates, and this is more as much practice as it is the letter of the Constitution, but the president, as commander in chief and as, sort of chief diplomat, he negotiates treaties. 2/3 of the Senate has to approve treaties.
Okay.
So that would, it's a combination of presidential and senatorial powers.
And are these cases, the Native American ones, we've got the water rights case and the adoption case. Right. Which one or both of these deal with an actual treaty that would take both rights?
The water rights case does. The adoption case, which, by the way, I hate to say the court got it wrong, but I think the court got it wrong.
Okay.
Or better stated, I think that it's totally appropriate for Congress to sort of lay forth or lay down, these are the priorities that you should have in adoption.
But is that what they did for the adoption for our listeners, I guess? Going real quick, so this is the Haaland versus Brackeen.
Yes.
I'm maybe pronouncing it terribly, but it's
I'm not sure how to pronounce it either.
They are talking, as I understand it, this is the 1978 Indian Child Welfare Act, the ICWA, that it's basically a law enacted by Congress, but is it technically a treaty?
I don't think so. I think the treaty falls in the water rights case.
Okay. So not the adoption case.
Not to my knowledge. And basically what the court said, as I understand it, is that the law requires, and therefore procedures demand, that the greatest priority in Native American adoption should basically be keeping tribal identity. Sure. And what's problematic about that is, and George Will had an article on this that I pretty much agree with, is that generally the rights in the Constitution are considered to be individual rights. Mm-hmm. And here you have sort of group rights. Right. Now, I can understand that for if someone chooses to remain or live on a reservation, and one has identified with a particular tribe, right, then it makes sense to me that by doing so, they are saying, We acknowledge this identity. It shapes who we are, and it would therefore be appropriate to shape who would raise our children. But in this case, as I understand it, sometimes 2 or 3 years after a family has fostered or sought to adopt a child, the Native American tribe says, hey, they're ours.
Right.
We're making a claim. And, traditionally, and Justice Thomas points this out in his dissent, and I'm, by no means am I an expert on domestic law, but one of the greatest priority or greatest principles, as I understand it in adoption, is the welfare of the child.
Right.
And yes, tribal rights are important. And certainly, if you look back in American history, there have been great injustices done to Native Americans.
Absolutely.
You and I both have been, have seen some of this in a Native American tribe. And so we're familiar with it. Mm-hmm. But to me, what is it? That latches, I guess, is the legal term. It seems like the law doesn't have, it needs a period where if you're going to make the claim, in my judgment, the claim needs to be made relatively early. It shouldn't be, we're familiar with a situation of, a family thinking they have a child, bringing it home, caring for it, and then having it ripped from them.
Yes.
And the trauma of that, for
both sides,
for particularly for those, we're at a time, especially now after Dobbs, if you think about it, if Dobbs succeed, if a number of states continue to prohibit abortion or severely limit it, unless people go elsewhere, more children are going to be born that are presumably either unwanted or wanted, but come in a family that's not able to care adequately for them.
Right.
And I think, to have that decision and then have a decision saying that some outside party, if it is an outside party, now again, if you're living on a reservation, if you've claimed membership in a tribe and it seems to be a valid identification, that's one. But even then, I would think that there surely ought to be a period. And so I would have approached this, I think, sort of on a due process grounds. Nothing wrong with with Congress saying this is going to be our priority. Native American tribes, need to be able to have their identity to perpetuate themselves. But I think they lost, in losing sight of the best interests of the child, I think they also lost sight of due process guarantees.
Yeah, that's interesting because it's such a strange case because they did adopt one child. Mm-hmm. Their son that they've already adopted is Native American. 2 different tribes is, I believe it's Cherokee and Navajo. And
I don't remember, but that sounds.
Yeah, I think that's what it was. And basically, the Navajo placement of that child fell through. So both tribes permitted under this act. So they actually followed the act. They permitted this couple, the Brackeen couple, to adopt the son. And then the issue now isn't about that son. It's about the daughter that was born, the sister, the half-sister.
Which is a sibling, right?
Mm-hmm. Half-sister. Of the mother had the child. So we're back with the Navajo tribe. And she entered foster care. The family has filed for custody because it's his sister, right? And in the normal interest of a child, if you can keep siblings together, most family law courts will say, yeah, that's
I don't know. In your case, you might have done better if you had been split.
I know, right? Can you please take my sister? Can we do only one adoption and it's her?
well, wait, she was the one saying to take you. You're right. You got it reversed.
That's true. So generally speaking, you want to keep siblings together. And it seems so kind. I mean, if the same couple is willing to take in a sibling, I mean, what an amazing act of love and kindness this is generally looked at. We have, you and I both know a couple back in Tennessee where you may not know they're going through this right now, but they have had they adopted a child, and the mother has now had 2 additional children. And they have done everything they could to adopt both of the other children so that their son has his siblings. Right. So it's a tremendous effort, and that's what they're doing, which seems this lovely, amazing thing. But now the Navajo Nation is saying, no, we want her placed with a distant relative of the mother. So they are laying claim to saying, we'll share custody. We can split custody, almost like it's an ex-wife and husband.
Divorce,
almost like a divorce custody of we'll share custody. You can have some and they'll have some. Almost like a visitation, supervision type of right. So they've appealed it. And it's weird because on the face of it, when I first saw it, I was like, oh my gosh, they're going to take the boy away. And it doesn't seem like they're going to take the boy away.
That's right. That's right. They're partly trying to establish a precedent, and I get that. All I'm saying is my reading of the law as it is right now, and you're the lawyer and I'm not, but my reading of the law is that it seems to lack some due process protections in there, particularly in terms of timing. And it may be, if a couple knows up front, this child you've been able to adopt, but if they're future siblings, you're not going to be able to, then they can take that into consideration when they make the decision.
Right.
But it does seem like, we want to make up for past inequities, but we need to be careful that in doing so, we don't create new victims.
Yeah.
And, what is their attitude going to be? Well, often it's going to be against the very group that, gave them their first child. So
right. And
that's the danger there.
Well, and that's the other interesting thing to me is the plaintiffs, this family, has actually claimed, well, it's equal protection issue, is we're being discriminated against based on us being white.
And that's, that's probably what we're going to get next week. We're probably going to have, now it's going to be more than likely in university admissions.
The affirmative action.
It is back to the, when is it appropriate? And in individual cases, it's certainly appropriate to make right past discriminatory conduct. But when that's broadened out to a group, then it may penalize another innocent group in the process of trying to make another one right. And so
and for this particular issue, and I want to ask you about this part here. The court has denied hearing. They didn't deny the equal protection issue, so they didn't say they weren't discriminated against. They just refused to rule on it, saying that none of the parties had standing to challenge the equal protection portion of the case. Were they being discriminated against because of their race based on this law? So it said, the ultimate issue they ruled on was Congress had the authority to make this law.
Right.
And the tribes can enforce it.
Right. And the term, Barrett, wrote this decision.
Yes. Justice Amy Coney Barrett.
And one of the fascinating aspects of it is she basically uses the term plenary. Congress has plenary authority over, and of course, Thomas denies it. And one of the odd things is when you get to the next case about water rights and about treaties are made with the understanding that you're dealing with another sovereign.
Yes.
And
that's
in that
what the
case,
Native American tribes are considered.
Right. And in that case, then how can Congress have plenary power? I guess they have maybe plenary power with the president to engage in a treaty, but anyway, Thomas in both cases is particularly concerned about that turn of events. And, Barrett is considered to be, or she's young, or, relatively new to the court.
A Trump placement.
Right. But I mean, she was considered to be very conservative, and conservatives are usually pretty reluctant to throw around anything saying Congress has plenary authority over anything.
Right, to expand the federal government power.
Right. Generally, they're more, these are the enumerated powers. Okay, there's some implied powers here, but now presidential power, they're often fairly strong on inherent presidential power. But when it comes to Congress, they're not usually quite that emphatic about it. So, I don't know if that gives us particularly insight into her, or whether it's just an anomaly of this case.
Yeah, no, it's interesting. Do you think that they're weighting the idea of these phrases of, well, it's not yet ripe, there's not yet standing? Are they setting it up where if they've actually filed for adoption and have been refused, that in that case they would have standing? Is that the setup here?
I don't know. And I mean, again, they probably already know how they're going to decide on affirmative action. And once that precedent, if it does, the current rule, basically the current rule is that you can consider race, particularly in admissions when it comes to diversity and whatever, but you can't do something simply on the basis of race.
Which is what this law is the ICWA gives preference to Native American families for placement, basically placement based on race.
Right. And that would be, that's something of an anomaly. Again, great injustice has been done to Native Americans.
Absolutely.
And so, but sometimes the force and the counterforce is equal when, maybe equal counterforces ends up hurting somebody else along the way.
Yeah, it's hard because these do seem like family law issues. And what is the best interest of the child? And the majority seems to say, well, Congress knows what it is.
Well, and typically domestic law falls under the 10th Amendment, right? These are, property laws, education, domestic relations, criminal law,
to the states.
For the most, with prohibitions against discrimination and against, illegal searches and seizures. These are decided at the state level.
Yeah.
And again, generally your conservatives on the court are those who are very deferential to state control over local matters.
Right.
And I don't know, I can't remember if it's this week or next week that we're going to get into the transgender issue.
Right.
But one of the issues there, I mean, one issue is, well, what is the degree to which this is a matter for the states as opposed to a matter between, and of course in Dobbs is the same thing.
Right.
To what degree is abortion, is that a state issue, or is that an issue primarily between a woman and her doctor?
Well, and in this case, it seems like a difference, because if Dobbs is giving the abortion rights back to the states, then why would the court now give Congress rights over part of the reason
over adoptions? And I may not have stated it properly, but this is where Barrett's statement, which is repeated in this Navajo case, in the water rights case, that Congress has plenary power to deal with this, does seem very much at odds with some of the other, developments in the law. So earlier, I thought we saw a convergence in agreeing that Congress has power, but here, maybe there's a divergence between what are we going to leave with the states and what are we going to allow the national government to do.
Yeah. All right. So with that, let's check out the water issue. So we've got the second Native American case, also the Navajo Nation. And so that was this week. And
Thursday.
you have, Thursday for, let me make sure I've got it right, the Arizona versus Navajo Nation.
Yes.
And so what is the issue in this case? We know it's the Navajo Nation. We know it's not adoption. But what law are they working with that's based on Native American rights in this one?
Let me say that there's a little bit of dispute between the majority and the minority as to what the case is about.
Close decision, 5-4.
Right. And the majority says, and I believe it's 1868, but I'm not positive of that.
An 1868 treaty, another treaty.
Right. It's basically a treaty.
Or the treaty. The other one was a law.
Right. Where, the Navajo Nation had been, as as European Americans expanded into the West, they were displacing the Navajos. They moved them for a time, I believe to Oklahoma, but I may be wrong, Montana, Oklahoma. They moved them to a place which was basically barren, and where the Native Americans said, we just can't, this is not our home. We can't live here. So they moved them back. Right. They moved them back. 15 million acres, basically, at least that's what they have over time, that's designated as a reservation. And in the last 20 years, there has been a water shortage. Viewers probably know, there's been great concern, particularly over the Colorado River.
Right.
It is, it's currently divided. Well, the rights to water usage on the Colorado River are currently divided among states, and the Navajo claim that they haven't really been given a seat at the table, and that the national government has made promises to them that they haven't kept. But the way the majority sees it is this is governed by the original treaty, which gave the land to, or returned the land to the Navajo. And they say that treaty required that we build some bridges, that we set up schools, that we provide seed for 3 years, and that they had the rights to any water that was there, whether it was in an aquifer or a creek or a river or whatever it was. The Native Americans say, well, you did more than that. You accepted trusteeship, and and here your knowledge of the law is going to be better than mine on this, but apparently there's sort of there's a generic trusteeship, and then there's a much more, and the Native Americans are saying, you basically promised us when you moved us here that we were going to have the water that we need. And the government says, well, we promised you these acres, we promised you that you had access to the water that was there, but we did not promise you a specific amount of water. There was the government says our job is ended when we guarantee you the access to the resources that are there. The Native Americans say, no, our understanding of trusteeship is you got to give us water if we don't have it. And apparently there are a lot of homes here that don't even have, running water in their own houses, which, in the United States seems to be, something that you would find in a third world country rather than here.
Right.
But the majority gives a very, I don't know if narrow is a word, but they basically, most contracts are interpreted fairly narrowly, right?
Right.
It's,
by the letter of the law.
It's either by the letter or the law. And the Native Americans are saying, well, elsewhere you've indicated that you're a trustee for Native Americans.
Right.
And so we think your responsibility is wider. I'm not sure what my view to me, it sounded like the court is making a reasonable interpretation of the treaty, but whether it does also sound to me, especially from the dissent, as though the national government has several times indicated that it was going to try to make sure that Native Americans had a fair share of water resource. They're in the Colorado River Basin.
Right.
And maybe it has not stepped up to that responsibility, which I'm not sure is by treaty or not.
Well, does the government have, and I understand Arizona's in this, so it looks like other states are in here. So are they
I think
all
there's like 4
asking?
or 5 states.
Are they all asking for distribution of the river? What is
I mean,
happening?
there are interstate compacts which currently govern, and you may, within the last month, have basically been renegotiated. Essentially, they've decided that if everybody gets their current allotment, there's going to be no Colorado River left. And so, but the Native Americans at least believe, and the dissent gives some reason to indicate, that they have not quite had the seat at the table that they thought they would have had.
And this is, again, kind of like the other case, the adoption case, where they seem to leave open another way for one of the parties, and in this case, the Navajo Nation, to make another claim for the rights, to the water rights, where they seem to say they left open the right to intervene in other water rights cases. So it seems like there have been multiple ones through the years, including 1 or 2 that were closed a decade or 2 ago. But it seemed to be saying, wink, wink, nod, nod, not this case, not this law, but go hook up with that other case.
Well, maybe.
I don't know. I mean, it seemed to leave it open, and I'll be interested to see.
Well, and again,
it's not this treaty, but can it be something else?
Right. Again, the dissenters essentially say the majority has it wrong. They don't even understand what the Native Americans are asking for. They're not really, they're coming under this treaty because you haven't given them access through any other way, but that's really what they ought to be doing.
Right.
But again, which side is right? I'm honestly not sure.
Yeah, it just seems so hard to even understand. And sorry, have you got your camera there?
Yeah, it's the light, actually.
Okay. It's one of those things where in law school, Justice Sandra Day O'Connor opinions, it's like part 2A3, and then they concur with extra exhibit 24-2-1. It's like one of those decisions is Justice O'Connor back? Because it's very confusing as to they agree in part on this and not on this, and then there's another, and it's like, what is the decision?
That's... one of I don't agree with him as much as I used to, but one of the justices that I really admired was Hugo Black, because he always strove to write a decision that his father or grandfather or that a person who had not been to college would be able to understand.
Yeah.
And, but that sometimes means then, part of the law, a lot of the law is nuance. And the beauty of Scalia was, you always remembered his dissents, but maybe sometimes you remembered them because they were a bit overstated. Okay,
so pending, those two seem to be semi-defined and finished, but still waiting in the wings. I think the equal protection part is going to come back up. I think that's where it's coming is when they try to adopt, if they're denied, that would be the next case. But
and again, if it were me and I were trying to adopt, I think I would probably say I'm going to look elsewhere, and maybe that's part of the congressional intent. But the question is, are there enough Native? Maybe there are. Are there enough Native American families who can step up and take care of the need? I would assume that this is a problem that probably is greater among lower income, less opportunity areas, maybe more likely to have to give up a child or not be able to raise it.
Right.
So anyway.
Okay, so let's move to our final case for today. Allen versus Milligan. This is the Alabama redistricting case. And this is another, I don't know what is up with the court. It's another 5-4 decision. And I don't understand. As an attorney, I really don't understand what it did. It seemed to do something that did nothing. So help me here.
It's an apportionment case.
Right.
In which, as I understand it, congressional apportionment, I believe, congressional districts.
Right. Congressional
And
apportionment
Alabama,
of voting districts.
Right. And apportionment right now is usually left up to state legislators, and they, typically have to do it every 10 years after each census. And they've come up with a plan that leaves, right now, as I understand it, there is one minority majority district, which is to say there's
Correct.
one district in Alabama where African Americans dominate. And for better or worse, probably worse, many whites will not vote for African Americans, and many African Americans, given the choice between a black and a white, are going to choose a black. So my understanding is that the demography of Alabama has changed so that they could now draw a second majority minority district.
Okay.
But that they chose not to. And the court, as I understand it, says when we compare the reapportionment plans, the one that provides for two minority majority districts is actually as close to compactness, contiguity, historical boundaries, the principles that one would generally apply, and what the court has struck down on occasion. Court has struck down a number of racially gerrymandered districts that look like it.
Right.
In other words, it looked like an ink blob. There was one case, I believe, out of North Carolina, but I may be wrong on this, where the joke was that for half the district, if you had gone down the center of if you had gone down a road with both your doors open, you would have wiped out half the population of the district, because there was this little string connecting, this nodule up here with this nodule here, and one down. The traditional. It was beyond a salamander; it was more like an octopus kind of configuration. And so my understanding is the court, and again claiming to interpret I guess it's probably the Voting Rights Act of
correct.
Voting Rights Act of 65 has been reaffirmed a number of times.
And specifically Section 2.
Right. And what's to be remembered with the voting rights law is that not only do you have the equal protection provisions of the 14th Amendment, but you also have the 15th Amendment, which was designed to provide voting rights to those who had been previously enslaved, so to African Americans. And basically, the court is saying that their interpretation of the law is that when you can provide minority representation, that you're not bound to have complete proportional representation according to race, but where it is possible to construct two districts where African Americans have a good chance of winning the district as opposed to one, that you should do that.
Okay.
So again, now to go to the Native American case, and maybe I'm not completely consistent on this, because here you would be taking race into account. Yeah. Albeit, you're doing so on the basis of two amendments, three amendments, if you count the 13th, which eliminated slavery, which were specifically directed to protecting and enhancing the rights of African Americans.
Yeah, they were the Civil War amendments, right? 13, that's 14, right. And 15 were created for African Americans.
68, 1870, that's right. So, but what's fascinating about it is, and I think we've discussed on this program before, and we'll say Russo, but I may be Rizzo, maybe I'm getting the wrong name here, but there's an important case within the last 2 or 3 years where the court has said it's not going to oversee, well, not with very much scrutiny, oversee partisan gerrymandering. Okay. Which means, the party in power trying to either, there's two terms, what are they, cracking or compacting. Their second term isn't right, but there's, we're not going to intervene simply because one party is trying to configure the districts to help them in the next election. And the basis is basically they think that this is just something that the courts don't have enough expertise to do. And they're trying to avoid, it's sort of the old political questions doctrine. We don't want to get involved in direct political issues. It's up to the political branches. The problem, of course, with declaring it a political question is that you then give sort of carte blanche to politicians to simply, configure districts in a way that will help themselves rather than represent the true, balance of the state.
So with this case, what is Alabama supposed to do based on this holding? Are they supposed to keep that district?
My understanding, and you're right, there's a lot of complexities to it, but my understanding is the court says, we've looked at this, you have a plan here, more consistent with the Civil Rights Act, or the Voting Rights Act, which gives you 2 districts rather than 1, and so you need to go with those 2. Rather than just the 1 district. That's my understanding of it.
Wow. Well, we'll see what they do. Okay, so thank you very much for being on here. This is extremely interesting. They're very detailed and complex. So
yes, they are.
I really feel like I still am not quite sure what was decided, although I think I talked like I did.
Well, so maybe I'm not a good enough teacher.
No, I think
we've only had a day or two to mull over some of these, so
and that's
give
true.
ourselves a little.
Right, and at least one of them was like 112-page decision. I'm like, oh my gosh. So yeah, okay, good.
Who do they think they are? John Vile, right? Why are they writing so much?
That much? All right. Well, thank you so much for joining us again. I am very much looking forward to next week, where we are going to hopefully find out about the affirmative action case, as well as a couple of others. And I know we have another special episode coming up on transgender issues and the ethical issues in the court. So stay tuned with us. Join us. Hope you had a wonderful happy hour, that you grabbed a glass of wine and joined us, and we will catch you next week for the hottest legal topics of the week. I'm Virginia Tehrani, and this is Dr. John Vile, and we will catch you next week.